Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number JV150399, Sandra T. versus Trevor A. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and the party you represent. Each side will have 20 minutes for argument, and Mr. Berkshire, as the appellant's counsel, you're responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs, and we've conferenced the case prior to argument. So with those preliminaries, Mr. Berkshire, you may proceed.
Morning. May it please the court, my name is Keith Berkshire, attorney for the appellant, Sandra T., who I'll refer to as mother. The main issue in this case, we believe, is that the trial court allowed father to benefit from failing to answer his discovery and from failing to answer trial questions related to that discovery at trial.
Does that error, in your view, affect the statutory grounds for severance or the best interest analysis? Because the court did find abandonment as a statutory ground, correct?
Correct. They did find abandonment, and obviously we're not appealing that issue. However, abandonment is the one sub-statute under 8533 that can't be used in and by itself to meet both the statutory factor and best interest. So in that regard, we pled mental health both as a statutory ground and under the factor for best interest, because some of the other grounds, the other statutory grounds, can actually meet both prongs of the termination test.
When you say meet both prongs, I'm not sure what you mean, because abandonment can be considered. In fact, we have a case saying that a parent who's abandoned a child is presumed to act not in the best interest of the child. So,
however, there's also case law, Judge, that says abandonment in and of itself cannot meet best interest. While there is a inference that it leads that there's, and I cite to this case in my brief, that it leads to a diverging of the parent and the child's interest that would presume against best interest. There's case law, to be frank, that says it can't meet both. So we did plead mental health. And due to, obviously, years of family court proceedings in this case, we pled mental health as both a statutory factor and to be considered under the best interest analysis.
But not finding it as a statutory factor doesn't preclude its introduction as part of the best interest analysis. And
absolutely,
to the extent it's there. So I guess the failure to find it as a statutory factor doesn't necessarily change the analysis one way or the other, as long as the court properly considers it as part of the best interest determination.
Correct. And obviously, because the statutory factor has to be met by clear and convincing evidence, while best interest only has to be met by preponderance, you are correct that finding under not meeting it under the mental health prong can still be used as part of the best interest analysis. And that's where we have the issue, is that, as you can see from the record, there was at least 3 different occasions that the trial judge compelled father to respond to the discovery. I mean, at the end here, he was given 8 additional months to answer his discovery questions, and multiple times stated in open court that he would, multiple times was given extensions, and ended up never doing this. The issue is that at trial, and specifically stated in the minute entry, the trial court allowed him to not answer, and then stated because he didn't answer, we didn't have any evidence, which is the issue. If there's a specific paragraph on it's under the mental health prong, under the statutory factor, not under the best interest, but I think it's very important because it is completely contrary to existing case law on ability to cross-examine. And I hate to just read these, but the paragraph states, the court therefore intended to draw a negative inference that if father had responded to mother's discovery request regarding his mental health, those responses would have supported mother's claim that his parental rights should be terminated under 8533B3. Absent any contrary evidence, the court would only have that negative inference to consider on this issue. But at trial, in response to mother's counsel's questions, father testified he had never been diagnosed with any mental health conditions, and he had not submitted to a psychological evaluation in his family court case. While father is not a credible witness, there is no evidence to rebut his testimony. That's specifically contrary to what the U.S. Supreme Court stated in the Fitzpatrick versus United States case, where it stated a party has no right to set forth all the facts to the jury that are in his favor without laying himself open to cross-examination on those facts. So when I asked at trial that father be defaulted and sanctioned for not responding to my questions at trial, the court refused to do so. So the trial court in this case allowed father to do what the Supreme Court said he can't, testify about what helps him and refuse to testify about what doesn't help him. And that's the issue here. We had gone through, I had asked for discovery very early in this case, in September. It was actually September 11th, 2014, over 13 months prior to trial. We'd asked ability to do discovery, and the court had compelled it multiple times. Despite that, the trial court did nothing about his failure to answer the questions. They didn't sanction him in any way. They didn't hold it against him in any way. They did nothing when he refused to answer my specific questions, whether he'd ever seen any mental health provider. They allowed him to testify that he had no illnesses, but when we got into whether he had seen any mental health providers, which we know he had, they didn't allow. The court didn't do anything when he refused to answer that question. And that's where we believe the court...
But the court did say it was drawing a negative inference. And
well, they said they would have. But it said, the specific minute entry says, absent evidence to the contrary, the court would have drawn the negative inference in this regard. But at trial, in response to the questions, he provided contrary evidence. So while they would have, they didn't. And that's the issue, is they took only what he said as the evidence. Even though they found him a completely non-credible witness, the only evidence that came in, that was allowed to come in, because the court didn't sanction him or force him to answer the questions, was when he stated he had no mental health issues.
Well, there is other evidence. This is kind of a unique type of evidence in that the defendant the person is actually there testifying, and there's mental health goes to conditions that other people observe, and so it doesn't necessarily prevent someone else from coming in and arguing this is someone who clearly has these qualities that suggest a mental health issue.
Well, and actually that was one of my objections to the court allowing him to appear telephonically at the last moment when he fled to Canada and admitted that he did, part of it was to evade the arrest warrant. Part of my objection at the beginning of that hearing, day one of the trial, was the court can't judge anything about his demeanor because he's not here. And the trial had been set for 11 months. So that was the reason we wanted him here, so that the court could judge that, as Judge Palmer and Judge McKiddish had done. And in things like when at one of the prior hearings, which was admitted, a transcript was admitted as Trial Exhibit 128, when father was cussing out Judge McKiddish during one of these hearings. So we wanted him there to testify. So he got away with both, sitting there quiet on the phone and putting it on mute. The court couldn't judge his demeanor, which obviously we also objected to, was him appearing telephonically.
But what evidence was there of negative interactions with the child? Was there any evidence of that?
Well, not only was there evidence from the family court case, because again, this family court case has been going on for prior to the child's birth, essentially. There wasn't not only evidence in the family court case, there were judicial findings from Judge Palmer in the case about how his anger issues specifically impacted the child. In the, I think it's March 8, 2013 minute entry, the court found how his actions specifically affected the child, and found, this is Trial Exhibit 177, that father's behavior poses a real threat to the well-being of the child emotionally, even if not physically. So, and that is one of the things that also, on my second issue in the brief, was that we think the court misapplied the harm test, in that held it too narrowly that it had to be some physical harm to the child. And the court repeatedly in the minute entry said there's no specific harm to the child or physical harm or threats to the child. That's not, I think that's a very narrow reading of what the statute requires. And again, this is a unique case because we already had the same parties on the same issue and at judicial findings multiple times in the family court case where there was harm already found.
But there's a very different calculus in a severance proceeding from a family court proceeding, because you're dealing with a the constitutional right, which is a fundamental right to parent custody and control of a child. And so I understand that that would be some evidence relevant to the severance proceeding, but to say the same issue and the same parties, I'm not sure I agree from a legal perspective. I mean, you would agree there's
I
a
understand.
difference in severing parental rights versus getting no access to a child.
I completely agree, Judge Downey. I think there is an absolute difference. However, in this case, the trial judge simply stated as it was basically poor behavior, and didn't go to the level of looking at it as that it could be potential harm. I mean, we have other cases come out of this court, like the Nash case, that talks about posting negative things about about your former spouse can have a negative impact on the child and be harmful to the child. That wasn't considered here. It doesn't.
But I mean, you do this work, and if in every post-decree high conflict case where we have a parenting coordinator and supervised exchanges, we can't just terminate the abusive parent's parental rights.
While I agree, I don't think you can overlook the behavior either. And in this case, the court simply said, well, we think the family court can deal with it. And they also implied in one of the last sentences of the mid-entry, well, he's not seeking time anyway, because he hasn't done anything anyway, so what's the harm? The family court can handle it, because he's not even there. And he's going to get arrested if he shows up anyway. So he's not even part of the kid's life. So, essentially what's the difference in this case?
But isn't that somewhat relevant in terms of what's the immediate benefit? If we're just talking about some emotional harm that may or may not arise down the road, it seems like it is at least a factor.
I'm not saying you can't consider whether the family court can deal with it. I think the issue here is, this is, as Steve Sheldon stated, who was our PC, one of two cases that he's ever dealt with that were this extreme, including the time he was on the bench and head of the mental health committee. This is that extreme of a case. This isn't a standard post-decree parents, yelling at each other at exchanges. This is the most extreme, where somebody, a retired judge used the very rarely used emergency power of a parenting coordinator to suspend time. This is where father then, after an order was, I don't think the clock ever started.
It's not running.
What, didn't even see it?
I don't really know. Is it working, or?
It's been 10 minutes.
10 minutes? Is the clock working? Oh, sorry about that.
7 to 10.
So we know. Okay, all right, thank you. I'm sorry to interrupt.
I wasn't even paying attention
We're
to it.
having so much fun.
I
You didn't
know.
look at the clock.
But it's still not running.
Yeah, it's.
It's been a great day for technology.
Yeah, we've had, our computers have been a
glitches.
mess, everything's been a mess,
Yeah.
so,
Happens after a vacation day.
yeah,
Okay, that's good.
close enough. All right, there we go.
There we go.
It's good enough. Okay.
But what I was saying was, this is one of those extreme cases. This isn't a situation. I mean, Judge Downey, you were on family court. How often courts, completely suspend parenting time due to, psychological evaluations and those things, when there was a joint custody order in place. This is where father tried to take the child, and we had police reports in exhibits where father tried to take the child despite a court order saying he had no parenting time. I mean, this is an extreme case in that situation.
But what about I'm sorry.
Go ahead.
What about the abuse of discretion standard, which is, not the appellant's friend? Maybe we would have ruled differently, but isn't this a view that a reasonable trier of fact who sat through the hearing could reach on the best interest determination?
I get the termination cases from specifically the best interest finding are about as wide discretion as you can possibly give to a trial court, given the case law. However, it's hard to get past the fact that the trial court didn't do anything about him not answering my questions. There should have been something there. Discretion ends where my client's due process rights begin, which is I have the right to ask him questions, and he doesn't have the right to clam up and say no. His testimony should be stricken or he should be defaulted. Those are the options. The court didn't do any of that. And the court specifically stated that I'm not going to enter any orders or defaults at this point, but I've ruled on the issue. I see it's an issue for the case. I'll deal with it accordingly. But the court didn't.
Default's a pretty harsh sanction, especially after Hayes v. Gama. I mean, wouldn't it have been satisfactory from your standpoint if the judge at least had taken a negative inference?
Well, and if there was a negative inference of this case that is mental health impacted the child, then we met the best interest standard. So, and that's what I'm asking for here is he refused to answer. I mean, there's no question the guy's not going to answer this. Is the result is you refuse to testify. You don't get to testify only about what's good to you. You have to testify about everything. Otherwise, it defeats the purpose of cross-examination.
You had said something earlier that intrigued me, and that was, you said that he denied he'd seen a mental health professional, and you knew that was false.
Well, he refused to answer, and we knew that he had. One of the exhibits, and I don't know off the top of my head, was credit card records that we had gotten from him in the family court case, because he gave us nothing during the termination case. And those credit card records have mental health.
So why couldn't you have introduced those credit card records
Well,
to rebut and say, he's not answering my question, Judge, but here's some evidence that he did see a mental health professional?
We attempted, and we were denied on foundation from the standpoint of we couldn't tell what the line item was. Because no one could testify about what it was because there was no we couldn't provide foundation for his credit card records. I don't know where that is in the transcript, but it was an admitted exhibit was his credit card records.
And you had no other evidence that you could have brought in to show that he had seen a mental health professional?
Well, and that's we knew he had from the standpoint of he had told my client, and my client testified about that, which is why we asked the discovery in the first place, so that we could get his records. And as you know, under Rule 49 of the family court case, it's mandatory disclosure, which again he's never done, and which was part of the if he would have undergone the psychological evaluation of family court, we would have received it.
But so your client could have testified that he had said he had seen a mental health professional?
My client did testify, and it's actually in the minute entry that she stated that he had told her that he was diagnosed as bipolar. It's actually in the minute entry.
So the judge had evidence going both ways?
Well, but the judge said discounted my client testifying about it because we had no additional evidence other than what he had supposedly said to her, which is the reason we sent discovery. I mean, this isn't something that we did out of some, fishing expedition. I mean, this is 4 years of family court where anybody involved with him stated he needed to undergo mental health evaluation. One of the other things that I think the court inappropriately used against us, and I think I'd like to say ironic, but it's really not laughable here, is the court stated all we had to do was ask the court to force him to undergo a mental health evaluation in the juvenile case, as if he would have complied. Because any mental health evaluation, the first thing they're going to do is give me your prior mental health records, and which we know he wouldn't have provided because he refused to in any case whatsoever, including the family court case. So we think that's a disingenuous order of the court that, all you had to do, we could have solved all this to see if he would have had mental health issues, was order a mental health evaluation. We knew he wouldn't come to the state of Arizona, first off, because he had a arrest warrant out for him for $25,000 or $28,000 warrant plus another $30,000 that he owed it by that time at trial. So he wouldn't have shown up, as he admitted in the voir dire at the beginning of the case about whether he should appear telephonically. So the court holding against us, and they did hold it against us, that we didn't ask for a mental health evaluation when he had never complied with any discovery order. It just doesn't make any sense because he had never complied with anything. Why is, the first 3 times we ask you, you're not going to comply, but number 4, you magically will.
The issue I have, it goes to the abuse of discretion standard, but this is a little bit different in that you have compelling evidence just of behavior. And regardless of the label that's put on it by a mental health professional, does it make that much of a difference if it's because he's bipolar, if he has anger management issues there? I don't think there's any question that there's an anger management, that there is some sort of issue that's evidenced by conduct. So why is it just because there's a label that's put on it by the mental health professional, why would that necessarily change the analysis? It seems to, this isn't a case where we don't know very much about the person. There's so much negative conduct that the court's able to see that regardless of the particular label that's on it.
Well, I think that when you got the records, as in any request for discovery, you're asking about stuff that you know and stuff that you don't know. And it could talk about other incidents, it could talk about other police incidents, it could talk about other, firings from work, it could talk about a multitude of other things that would have been helpful, which is why we asked for it. So we knew enough to get the discovery request's granted, and the court did grant it very early in the case. Again, we think there would have been more in there about his behavior that would have been relevant to the court, and not forcing him to do it was the
But
error.
someone who's been a jerk to many different people, I mean, isn't the focus is still the harm to the child here, and it seems like there's a more direct interaction as between mother and the child, and so other interactions, it seems like the court had the relevant information.
I think the other interactions and other things that could have discussed his overall mental health would have been relevant. I mean, we don't request discovery just on everything you know. Otherwise, why would you ask for it? I mean, there was most likely, based on other information we had, that there was other items out there, other incidents with other people that would have backed this up. But we have no way to do it, and that's why we asked for it. That's why the first thing we asked for at the first hearing on the case was this.
What if someone just has a religious belief that precludes ever seeing a mental health professional for whatever reason? If someone just absolutely refuses, and let's say they're not, it's not this type of conduct, but if someone just believes strongly that the mental health profession is not, it's not something they're willing to cooperate with, were we going to use it as a necessarily establishes?
I think there's a
that's
difference.
finding?
I think there's a difference when somebody says, I'm not going to go to a mental health provider, than somebody who went to a mental health provider and didn't provide the records and refuses to answer questions about it. I think that's a different issue. And that's what we had here, was we had discoverable information that the court did nothing about when we asked for it and when he testified about what was favorable to him only. And with that, I'm going to say my last.
You had the credit card records, right? Showing who the mental health provider was. Is that right?
We had a line item on a credit card that appeared as if it was a mental health provider.
Could you have subpoenaed tried to subpoena the
Out of
records?
state. I mean, it was out of state in Maryland. We could have, theoretically, yes. Again, but if, as in most of those, they clam up and say HIPAA and won't release them without a.
Arizona law, they can submit the records if they don't get the consent of the patient.
It wasn't.
They can submit it. They can, which I'm sure they wouldn't. They can submit it under seal to the court.
It wasn't an Arizona provider was our first issue on that, was that the reach of the.
But there are lots of times. I mean, you can get a subpoena and then have it enforced through a proceeding in a different jurisdiction.
And specifically, the discovery request that was ordered by the court was for him to sign the HIPAA releases so that we could do that,
Okay.
which he didn't do.
Okay.
And that's why we asked for it that way.
Thank you. Mr. Lopez.
Good morning. May it please the court. Bernard Lopez, attorney for the appellee, Mr. Trevor. First and foremost, father wants this affirmed because the judge here, the court here, was a trier of fact. He had all of the available necessary information to make the rulings that he did. His discretion was used properly. That first issue regarding the discovery, he did do something about it, and that was stating that he would take the negative inference on that. He did subsequently get some testimony from the father, and that was enough for him.
What do you make of the court saying mother hasn't presented evidence, and the reason she doesn't present evidence is because it hasn't been turned over or hasn't responded to discovery?
Well, as far as the evidence that was presented to the judge, it wasn't directed. That's what he had. As far as the mental health records, and I think that what my colleague here is stating that he should have under the rules done something, but he had discretion there, and in that discretion, that's why he said he was going to take the negative inference. This is a termination case where we know the juvenile court has the exclusive jurisdiction. Under their rules, it does not state that they shall take those negative or sanction the sanctions that are in the civil rules of procedure. In fact, the civil rules of procedure generally don't apply when the juvenile court is using its own rules.
Is it an abuse of discretion when you put the burden on someone to produce evidence and they make the request for it, and then the other side resists those discovery requests? And if you're saying it's your burden and you didn't meet your burden because the other side didn't cooperate, that seems inherently unfair.
I think that is too, but there were opportunities to submit evidence, to submit what could be used, to submit what the judge could use in finding it clear and convincing.
What were those opportunities? I mean, they didn't have the HIPAA consent form because he refused to sign it. He then testifies in his own favor and then refuses to answer questions after refusing to produce discovery. What opportunities did the other side have to present evidence that would contradict what he testified to?
I believe that the judge stated they could have done the Rule 35 psychological evaluation. They could have taken more testimony from the mother about what had been accumulated in terms of what his mental health issues were. But the evidence that the court had was enough for this judge to say that it just wasn't enough, even after this gentleman, the father, testified. The best interest, I think the judge ruled properly on that as well. It's distinguishable from both cases, both Demetrius L. and Jose. And in this case, there was no one an adoptive parent. That was the other two cases had that person waiting in the wings. There was a family court case going on where there were actually there was an order still pending for father to comply with in order to get time with his son, time visitation, and so forth. So there's an active family court case.
But how long had that been pending?
I believe it was 3 years, something like that.
Doesn't that,
Well,
when you have
maybe
a 1 year period, that seems like it's not very compelling evidence that there's something pending helpful to your client.
Well, the fact is the father was still pursuing to be a part of the child's life, regardless of his problems and his issues. And family court orders were trying to get to a point where he could be in a relationship that was healthy and appropriate for the child. That's why the court said, take it back to family court, fix all this stuff. The benefit to the child is going to be that there's still a father out there. The harm issue, there's no direct evidence of the harm. The harm was all to the mother. And yes, the emotional, we understand the emotional issues that domestic violence and arguing can cause with a young child, but those problems weren't there because, as Your Honor earlier stated, that really the interaction with the child at that point was with the mother. The father was just trying to get back into the picture and be a father. Now, the court can presume that the trial court considered all of the evidence, evidence that it had in reaching its decision, not that it left out anything in making that decision. I believe he was trying to save the parental relationship because there was an opportunity to do so because of the family court case.
Is there some point at which you would agree that it would become an abuse of discretion if father waits another? Does mother just have to wait 18 years with no interaction from father if he can't have any time with the child unless he cooperates with some sort of mental health evaluation, and he's not willing to do that? The child just remains in limbo for.
I think at some point, yes. Like I said, the case is still open. With the family court case is still open. Yes, I believe there would be a point where it would be appropriate to sever that relationship. But
After 4 years, after 5 years or 6 years, is it?
But the father was still trying. The father had that case there. He didn't. He appeared at the hearings. He was showing that he wanted to maintain his relationship, and I think that even though his contact was minimal, he was still.
Is there something pending now? Is there a hearing scheduled at some point?
I'm not sure, Judge. I don't think so. I don't think so.
Doesn't
I
have
think
any
there are
pending
some pending orders that he has to comply with and then return.
Father hasn't challenged those orders, so he hasn't expressed any intent to have those evaluations or do what's necessary to get time with the
No,
child.
Judge. No.
So how do we determine how long is enough?
I don't think.
Does mother have to file a new petition for sever and say, okay, he's abandoned, there's already been finding of abandonment, nothing's changed, and then have a second shot at trying to prove the mental health aspect?
I think that would be her remedy, Judge.
So you're saying that wouldn't be barred by the determination here, as long as there's new evidence
Yes.
or some other factor that would be the best interest of the child,
Yes.
such as father not complying with the family court orders?
Yes. Or it's possible the combination of factors. Maybe she gets married or something like that that would make it more of a, or at least add to the factors that would benefit the child. Any further questions? I don't have anything further.
Thank you. Since we used up a lot of Mr. Berkshire's time with questions, I'm going to give him 2 minutes for rebuttal instead of 29 seconds in the exercise of my discretion.
Thank you, Your Honor. Wide discretion. There is nothing pending in family court. Nothing's been pending for 2 years since prior to the date that the severance was filed. And the question posed by Judge Downey earlier about the presumption once you meet a statutory ground, I wanted to touch on that briefly. In both the Kent K case and JS150399 that I cite in my brief, those are the cases that specifically go through the idea that once you've met the statutory ground, it's a presumption against the best interest factor. And like I stated earlier, no case in Arizona has gone and stated that abandonment can by itself meet that. But I think the questions posed by Judge Kessler go towards that. How long does somebody have to wait? Let's say you just waited, just no contact for 15 years. Can't that be enough? And that is the situation here. The last time father saw the kid, the child was barely 1. It was in November of 2012 was the last time the father had any contact in any way with this child. And as we went through with my client's testimony and all the family court orders, father never tried to comply with the court orders about about his mental health or getting an evaluation or anything else. He repeatedly filed petitions. He filed 2 petitions in the 3 years after that, asking that those just orders go away because he didn't need them. And that's the issue here, is that he's never done anything to try to do what the family court directed. And so leaving this to the family court dealt with it, and he refuses to do what the family court states, which definitely goes towards best interest, because he is just violating the court orders. Now, the violation of the court order is he doesn't get parenting time, but nonetheless, he's violating court orders for the last 3 years about seeing his child.
But he is making a better case for your client with every passing day, presumably.
Well, correct. I mean, the abandonment gets stronger and stronger, but we never had an issue of abandonment. I mean, 3 years
But
of nothing.
even as the child is older, it's more of a trauma, presumably, to introduce. There are other arguments, presumably, that can be made as time passes.
Frankly, I don't know how they get any stronger. I mean, this is a guy that the child has no idea, as the testimony was. He hasn't seen him since he was 1. The kid is turning 5 in this fall. He no idea who it is. I mean, at 3 years, we thought that was enough. I don't see the difference between 3 and 6, frankly. Not knowing is not knowing. And I've eaten all my extra time. Thank you.
Thank you. Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. And at this time, the court stands adjourned.